Dear learners, we shall be starting with the part 4 lecture on the kinds of business organization. This lecture we shall be focusing on a very important principle that affects all business organizations, especially in the context of its ability to attract investors and investments. This is known as the limited liability principle. Now, because the limited liability principle is the most profound in case of a company, so we will be discussing it along with the company, although this is something that is relevant to all other business organizations, whether it has got limited liability or unlimited liability. So in the previous lecture, we had taken up the separate legal personality part. Now we'll begin with the limited liability part. Now, the expression limited liability is not directly defined under the Companies Act 2013. It is defined in the context of a company limited by shares under section 2 subclause 22. So this remains a provision where the limited liability to some extent is introduced to us. Now, according to this provision, company limited by shares means a company having the liability of its members limited by the memorandum to the amount, if any, unpaid on the shares respectively held by them. So the expression company limited by shares can be misleading, as the word limited here denotes that it is the liability of the members of the company which is limited and not specifically of the company itself. Now, we shall deal with a company limited by shares in more detail under the topic kinds of companies, which will be taken in a subsequent lecture. Now, to simplify this definition for you, it is slightly technically worded. Limited liability means the liability of the members who have contributed to the company and have got shares is restricted to the value of their shareholding. The shareholder's shareholding is the investment in their company. Now, the liability of shareholders in a company is with reference to their investment in the company. It cannot be extended to their personal assets. So if a company is facing financial trouble or difficulty or distress in a situation where its assets are less and its liabilities to the creditors are more, then the personal assets of the shareholders, they remain protected from any claims which are made by the creditors. In other words, the claims of the creditors are limited or restricted to making claims against the assets which are held in the name of the company, and they have no claim against assets that the firm's shareholders hold in their own names. So this limited liability essentially performs what we call as a protective function for the shareholders. It protects the shareholders from company's debts by clearly demarcating that the debts of the business remain debts of a company, which is a separate legal person, and debts of the shareholders, like their personal debts, like a house loan or a car loan, they remain their personal debts and cannot affect the debts of a company. So the shareholders are completely free from any liability towards the company's debts. So the debts of the company are not the debts of the shareholders of the company. Now let us take an example to how the limited liability principle works. So we have an example where there is a person A who has bought 100 shares of company X at the rate of rupees 10 per share. So multiplying the total number of shares with the value of each share, his total investment is rupees 1000. Now let us assume he has paid rupees 500 or 50% of the value as part payment at the time of allotment. Now in a company, the investors do not have to pay the entire value of their shares in a single installment. So the company may choose to have the shareholders contribute their investment in multiple installments. So in this case, the company has called upon the shareholder at the time of allotment to pay only 50% of the value of his shares. Now he cannot be called upon to pay more than rupees 500. That is the amount remaining unpaid on his shares. If he holds fully paid up shares, meaning thereby he has paid the entire value of the shares, then that shareholders has no further liability to pay even if the company is declared insolvent, meaning thereby it has outstanding debts which is not able to pay to the creditors. The liability of the shareholder stops when he pays the entire value of his shareholding to the company. So this is what limited liability looks like in action. By protecting the company's business creditors from making any claims against the personal assets of the individual shareholders. Now, this case again is a manifestation or reflection of what was laid down in the case of Salomon versus Salomon and Company Limited that we discussed in the previous lecture on legal personality of a company. Now let us further analyze what are the effects of operation of the principle of limited liability, and essentially we shall be looking at who stands to benefit from this principle of limited liability. So this is what we call as asymmetry in the rewards and risks, or the benefit and costs for two different stakeholders in a company, both who are financiers but have different roles and functions, that is the shareholders who are members of a company and creditors who do not become members of the company but simply get returns on the loan or a credit which they have advanced to the company. So first we'll take up the analysis of limited liability from the point of view of shareholders in a company. So let us assume that there is a person X who has bought 10 shares in a company, TCS or Tata Consultancy Services, for rupees 100. Now we'll be looking at rewards and risk which may entail to this particular shareholder. Now if you take the economic situation that the company TCS does exceedingly well in its business operations are very successful and it earns a lot of profits. Now in this case what we see here is that there is no legal bar or a limit as to how much of profits or dividends this shareholder can earn, or what is the total value of his shares which may go on the stock market. So the rewards here, they are kind of infinite. I mean, there is a possibility of the rewards being infinite. So they remain unlimited. So there is no capping. But let's say the opposite of this economic situation occurs, which is that the company business fails. It runs into losses. It runs into distress. Now, what is the risk, total amount of risk that this shareholder faces? According to this principle of limited liability, the liability of the shareholders is limited or restricted to the value of their shares in the company. So in this case, the total value of his shares is rupees 100. Now, shareholders in a business organization that has limited liability, it cannot go beyond their contribution in the company through the share, which is rupees 100. So what we find here is that there is a kind of a capping, or there is a kind of a limit, or the losses, they remain finite to rupees 100. So this is the asymmetry. The asymmetry is that there is no capping on the amount of rewards, but there is a capping on the amount of risk. So the rewards can be more for a shareholder in a business organization which has limited liability. Now let us analyze the principle of limited liability from the point of view of another stakeholder in a company who is also a financier, the creditor. Now suppose there is a person X who has given credit to Tata Consultancy Services of rupees 100 at the rate of 6%. Now similarly, considering the economic situation where the business of the company is very successful, it runs into profits, its business operations. So what are the maximum rewards that this creditor can get? He will get back his rupees 100 along with the rate of interest, which is rupees 106. So what we find here is that there is a capping, or there is a limit as to how much of reward he can get. Now, if the company's business is successful by 100% or 200%, 300% or more, the rewards he will get is restricted or limited to the principal amount as well as the interest that he is going to get. So the rewards here become limited. On the other hand, if the opposite economic situation occurs and the company faces financial difficulty or losses and goes into insolvency or goes into winding up closure, then the risk that this creditor faces is also of rupees 100 that he has advanced to the company, and obviously he will not be able to get back his 6% interest, that is rupees 6. So what we find here is that at the most the creditor stands to lose his entire principal amount as a bad loan or a bad debt. So bad debt are those kind of debts which cannot be realized. So again, there is a kind of a capping on the risks which are there. Now because there is a capping on the rewards and there is a capping on the risks, so this is a kind of a parity between the risks and the rewards. So rewards are also limited, risks are also limited. Now let us try to contrast this principle of limited liability from the point of view of both the stakeholders that we have just discussed, shareholder on one hand and the creditor on the other hand. So shareholder, there are no limits on profits, they can be unlimited. Now how much of profits they actually earn depend upon the extent to which the company's business is successful. On the other hand, for the creditor, there is a limit on profits, which is he will get back the principal amount as well as the rate of interest. So the shareholder, there is a limit on the risk, and for the creditor, again there is a limit on the risk. So this is advantageous to the shareholder, and this is equal for the shareholder as well as the creditor. So the risk is limited to the value of shares, and for the creditor the risk is restricted to the value of the loan amount. So again this is equal. So because of this first point, the limited liability is attractive for the shareholder, and for a creditor unlimited liability is attractive, because if the business has unlimited liability and the business is run on credit. So if for some reason the business fails and the business is not able to return the amount of loan it has taken from a creditor, then in that case, if the business has unlimited liability, the creditor can lay a claim on the personal assets of the shareholders or the owners of the business. So they have an additional source of recovering their amount. But that option is not available to the creditor in case of limited liability, because the shareholders' personal assets remain protected from the business creditors of the company. So that is why creditors generally prefer giving loans to those business organizations which have unlimited liability. And shareholders generally tend to make investment in those business organizations which have limited liability. A case in point is that of a company. Now, there are certain exceptions to the limited liability principle under the company law. First is that of an unlimited company. So, while the concept of limited liability company is very beneficial, however, under the law, it is also available as an option to the promoters of a business to establish a company with unlimited liability. Now, unlimited liability is a kind of a company that is defined under Section 2, Subclause 92 of the Companies Act. It means a company not having any limit on the liability of its members. Now, what is an unlimited liability company? This we shall discuss in more detail under the various kinds of companies in separate lecture. The second exception to limited liability is reduction in the membership of a company. So if at any time the number of members of a company is reduced, for example, in case of a public company below 7, so a public company has to have a minimum of 7 and maximum there is no limit. So if the membership comes down below 7, in case of a public company, and in case of a private company below 2, so 2 is the minimum number of shareholders which are required for a private company, and the company carries on business for more than 6 months while the membership is so reduced. So every person who is a member of the company during this time, when the business is carried on after those 6 months, and they are aware of the fact that the business is carried on with less than the prescribed number of members, then they shall be severally liable for the debts of the company which is contracted during that period when the membership was below the legally permissible limit. And therefore the creditor may sue them for unlimited liability if the company is not able to pay back the credit of the creditor. So this provision is contained under Section 3A, which constitutes an exception to the limited liability. Now, what is a public company? What is a private company? This we shall again be taking up separately under the topic kinds of companies in later lecture. Now, another ground which converts limited liability as an advantage to the shareholder to unlimited liability which is a disadvantage to the shareholder is cases of fraud. So where a company has got itself registered and incorporated by furnishing any false or incorrect information or misleading information or any misrepresentation, or by suppressing any information or fact or any declaration that it has filed before the compliance officer, that is the registrar of companies, or by any fraudulent action, then the courts like the company law tribunal may, on any application which are made to it, on being satisfied that the situation so warrants, they direct that the liability of the members of the company shall be unlimited. Now this is essentially for the protection of creditors. So if limited liability is a kind of a privilege or advantage, but if you have made any misrepresentation or committed any illegality in the registration of the company, then that advantage will not be available. Further, under Section 339, Clause 1 of the Companies Act, when the company is being wound up or facing closure, and it appears that the business of the company is being carried on with the intent to defraud the creditors of the company or any other persons or for any fraudulent purpose, then the court may declare that the persons who were knowingly parties to the carrying on of the business in such fraudulent manner, they would be personally liable without any limitation of liability for all the debts and liabilities of the company. Now, this limited liability principle becomes very crucial at the time of winding up of the company, especially when the company faces closure, because the company generally faces closure when it is in distress. And how is the distress measured? It is measured when at the time of closure of the business, there are certain creditors of the company whose money has not been paid back to them. So it is possible that those who are actually in charge of the company may try to sell off its assets or siphon off its assets so that the claims of the creditors cannot be met. So in that case, if the creditors are being illegally or irregularly being excluded from realizing their claims from selling of the company's assets, then the limited liability would be converted into unlimited liability for those persons who are committing such illegality. With this, we come to the closure of this lecture on what is a limited liability. So here we have discussed what is meant by limited liability, what are its functions, essentially a protective function for the shareholder of the company, and we have undertaken a detailed analysis of the limited liability from the point of view of shareholders in a company and creditors of a company, and essentially that limited liability is very favorable to the shareholders. So that is why many people, they make investment in the company by buying its shares, because they are protected by limited liability. And then lastly, certain exceptions to limited liability. So here we close our discussion on the limited liability principle of a business organization, mainly the company. We shall be continuing with our discussion on the characteristics of a company in the next upcoming lecture. Thank you.